Way to the Netherlands, lawyer Paul Gicheru is pleading with the International Criminal Court at The Hague to acquit him of all counts facing him, saying that the Office of the Prosecution has not linked him to the bribery of witnesses case. In his closing submission, Gicheru said that the Office of the Prosecution relied on hearsay and unsubstantiated claims to nail him.
Submissions before the trial chamber at the International Criminal Court in The Hague, lawyer Paul Gicheru, through his lawyer Michael Carvanes, punched holes into the prosecution case, holding him on counts of offences against administration of justice.
Did not give an opening statement. Where in the statute does it say that the defense must give an opening statement? It doesn't. And not to mention, an opening statement is not evidence.
Gicheru is accused of criminally responsible for 8 counts of corruptly influencing witnesses individually as a direct perpetrator jointly with other members of Common Plan, as a direct co-perpetrator in bribing witnesses to drop their ICC cases against Deputy President William Ruto at the Hague-based court.
Although I say that even Stevie Wonder, the great American blind, singer, could see what the defense was. How did this failure on our part compromise the OTP in presenting its case or negatively impact its burden of proof?
Gicheru's lawyer James Stewart Carvanes pointed out that the Office of the Prosecutor is expecting the trial chamber to find the needles of truth, if any exist, hidden in the massive haystack of lies by each witness, and the prosecutor did not rise to the level of proof.
The OTP argues that you may rely on one part of a witness's testimony while rejecting others, since no witness is per se unreliable. Well, even the clock is right twice a broken clock is correct twice a day. Fair enough. No witness is per se unreliable. But again, the jurisprudence of the ICC is somewhat more nuanced.
Carvanes claiming witnesses who were known to have lied were interviewed in an inordinate number of times to smooth out inconsistencies and improbabilities in the evidence or tailor it to the Office of the Prosecutor's case, and denied offering a bribe to a witness at gunpoint to stop them from engaging the International Criminal Court.
And they opt for what I call the skunk factor. You bring a skunk into the courtroom for a second or two, take him out. The skunk is out, but the stench remains. It's all about insinuation.
Prosecution urged the ICC to hold count Gicheru and not consider his submissions. The trial chamber said they're going to deliberate on the submissions. Serafina Roby for Prime Edition.